Garcia.
Thank you, Mr. President, and guests and colleagues. Will you please join me in the Pledge of Allegiance? I pledge allegiance to the flag
Of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Mr. Majors, please call the roll. It's good to see you.
Senators Aguilar, Baumgardner, Carroll, Cook, Crowder, Donovan, Garcia, Grantham, Guzman, Heath, Hill, Hodge, Holbert, John, Johnston, Jones, Kafalis, Kerr, Lambert, Lundberg, Marble, Martinez-Humenic, Merrifield, Neville, Newell, Johnston, Roberts, Scheffel, Scott, Sonnenberg, Stedman, Tate, Todd, Ulibarri, Woods. Mr. President.
Here. 35 present, 0 absent, 0 excused. We have a quorum. Senator Tate.
Thank you, Mr. President. Good morning. I move that the reading of the Journal of Wednesday, March 9th be dispensed with and that it be approved as amended by the Secretary of the Senate.
You have heard the motion. All those in favor say aye. Opposed, no. The ayes have it. The motion is adopted and the journal is approved. Reports of committees of reference.
March 9, 2016, Committee on State Veterans and Military Affairs, after consideration, the Mayor's Committee recommends following House Bill 1002 be postponed indefinitely.
Senate Services.
March 10, 2015, correctly engrossed Senate Bill 62, 115, and 116, correctly re-engrossed Senate Bills 58, 102, and 132, correctly revised House Bills 1046, 1082, 1083, 1139, 1144, correctly re-revised House Bills 1033, 1038, and 1284.
Third reading of bills, consent calendar. Mr. Majors, would you please read the title of all the bills on the third reading of bills consent calendar?
House Bill 1046 by Representative Kraft, Harper, Senator Baumgardner, concerning the response to hazardous substance incidents under designated emergency response authority responsibility. House Bill 1082 by Representatives Garnett and Willett, Senator Todd, concerning area vocational schools in connection therewith changing the name of area vocational schools to area technical colleges and adding representation for area technical colleges to certain boards. House Bill 1083 by Representatives Brown and Hamner, Senators Donovan and Grantham, concerning the role and mission of Western State Colorado University.
We wanted to come hang out with you guys.
Mr. Majority Leader.
Thank you, Mr. President. I move that the Senate adopt the bills listed on the third reading of bills for final passage consent calendar, which includes House Bill 1046, House Bill 1082, and House Bill 1083.
You have heard the motion. Is there further discussion on any of the bills on the third reading of bills consent calendar? Seeing none, are there any no votes on any of the bills? With 35 ayes, 0 no, 0 absent, 0 excused, House Bill 1046 is adopted. Co-sponsors, Senator Kafalis, Mr. Majority Leader, Senator Newell, Senator Todd, Senator Roberts, Senator Lambert, Senator Merrifield, Senator John, Senator Tate, Senator Woods, Senator Martinez-Humenic, Senator Scott, Senator Heath, Please add the president. Mr. Majors, would you please read the title to Senate Bill 10? Oh. Then read it at length. Belay that. With 35 ayes, 0 noes, 0 absent, 0 excused, House Bill 1082 is adopted. Co-sponsors: Senator Merrifield, Senator Stedman, Senator Woods, Senator Heath, Senator John, Senator Kerr, Senator Ulibarri, Senator Martinez-Humenick, Senator Marble, Senator Roberts, Senator Newell, Senator Carroll, Senator Kafalis, Senator Lundberg, Senator Baumgardner, Senator Donovan, with 35 ayes, 0 noes, 0 absent, 0 excused, House Bill 1083 is adopted. Co-sponsors: Senator Crowder, Senator Johnston, Senator Marble, Senator Kerr, Senator Baumgardner, Senator Merrifield, Senator Woods, Senator Todd, Senator Scott, Senator Lambert, Senator Lundberg, Senator Neville, Senator Sheffel. Colleagues, check your phones. One of you is calling me. Senator Martinez-Humenick, you know who you are. Senator Heath. Senator John, call me. Please add the president. Senator Grantham will be fined $5 for calling me. Texts are free. Unlimited texts. Third reading of bills, final passage. Mr. Majors, would you please read the title to Senate Bill 62?
Senate Bill 62 by Senator Marble and Representatives Becker, J., and Vigil concerning modifications to the regulation of veterinary pharmaceuticals in connection therewith making an appropriation.
Senator Marble.
Thank you, Mr. President. And I move Senate Bill 62 for Scooby-Doo on third reading and final passage and ask for an aye vote.
That's $1. The motion before the body is the adoption of Senate Bill 62. Is there further discussion? Are there any no votes? Senator Jones, Senator Aguilar, Senator Kerr, Minority Leader Guzman, Senator Kafalis, Senator Holbrook. That was Astro, not Scooby-Doo. Sorry, that'll be $2. With 30 ayes, 5 noes, 0 absent, 0 excused, Senate Bill 62 is adopted. Co-sponsors: Senator Sonnenberg, Senator Baumgardner, Senator Crowder, Senator Aguilar, Senator Scott, Senator Lambert, Senator Neville. Mr. Majority Leader. Senator Martinez-Humenic. Co-sponsors: Senator Aguilar,
I apologize. I do not want to be a co-sponsor on the bill I voted no on.
you have 1 minute to explain. Senator Aguilar.
I thought it was 1:15. My apologies.
I hope that doesn't happen on their scripts that you write. No wonder the co-pays are so high. Senator Aguilar will be removed as a co-sponsor. Anybody else want to be a co-sponsor? Mr. Majors, please read the title to Senate Bill 115.
Senate Bill 115 by Senator Martinez-Humenic and Representatives Moreno and Conti, concerning an electronic filing system for documents recorded with the county clerk and recorder in connection with creating the Electronic Recording Technology Board, which is an enterprise authorizing the board to set an additional filing surcharge for a 5-year period, requiring counties to transmit the proceeds of the board's surcharge to the state for deposit in a cash fund administered by the board, requiring the board to make grants from the fund to counties to create, maintain, improve, or replace electronic filing systems, establishing reporting requirements for the board, increasing a local filing surcharge, and making an appropriation.
Senator Martinez-Humenic.
Thank you, Mr. President. I move Senate Bill 115 and ask for favorable approval.
Is there further discussion? Seeing none, the motion before the body is the adoption of Senate Bill 115. Are there any no votes? With 35 ayes, 0 noes, 0 absent, 0 excused, Senate Bill 115 is adopted. Co-sponsors: Mr. Majority Leader, Senator Merrifield, Doctor, Senator Aguilar, Senator Kafalis, Senator Woods, Senator Baumgardner, Minority Leader Guzman, Senator Ulibarri, Senator Tate, Senator Lambert, Senator Cook, Senator Heath, Senator Garcia, Senator Roberts, Senator Holbert, Senator Todd, Senator Kerr, Senator Scott, Senator Marble, please add the President and Senator Grantham. Did you pay? Anybody else? Mr. Majors, would you please read the title to Senate Bill 116?
Senate Bill 116 by Senator Johnston and Representatives Lee and Lebsaw, concerning the creation of a deceptive trade practice under the Colorado Consumer Protection Act for private custodian of criminal justice records to fail to remove a sealed criminal justice record from the custodian's database after receiving notice of a court order sealing that criminal justice record.
Senator Johnston.
Thank you, Mr. President. I move Senate Bill 116 on third reading and final passage, and I do ask permission for a third reading amendment.
Please explain your request.
It's a small two-page amendment. No, I'm kidding. It's just a drafting change. We're adding SUB, the word subsection, instead of section. There was a cross-reference that was missed.
Again, depriving the House of an opportunity to show their prowess. The request is for permission. All those in favor say aye. Aye. Those opposed, no. The ayes have it. Senator Johnson. Mr. Majors, would you please read Amendment 5 to Senate Bill 116?
Amendment L005.
Senator Johnson.
Thank you, Mr. President. I move Amendment 5 and ask for an aye vote.
Is there further discussion? Seeing none, are there any no votes? With 35 ayes, 0 no, 0 absent, 0 excused, the amendment is adopted to the bill. Senator Johnson.
Thank you, Mr. President. I do just want to briefly thank both the chairwoman and the vice chair of the Judiciary Committee. When this bill came to the Judiciary Committee, it needed a fair amount of work. And they were very patient and very persistent, and I think taking what had some problems and turning it into a bill that I'm proud to be a part of, I think will make a difference. So I think sometimes these small bills don't get a lot of attention, but show the best of what I think folks do sometimes down here in terms of their patience and their perseverance. So thank you to my colleagues who helped make this a good bill. I'd ask for an aye vote.
Is there further discussion or any more nominees? Seeing none, the motion for the body is the adoption of Senate Bill 116. Are there any no votes? With 35 ayes, 0 no, 0 absent, 0 excused, Senate Bill 116 is adopted. Co-sponsors, Mr. Majority Leader, Senator Heath, Senator Lundberg, Senator Stedman, Senator Woods, Senator Kafalis, Senator Marble, Senator John, Senator Cook, Senator Aguilar, Senator Tate, Senator Roberts, Senator Donovan, Senator Neville, Senator Todd, Senator Merrifield, Senator Martinez-Humenick, Senator Newell, Senator Kerr, Senator Scott, Minority Leader Guzman, Senator Baumgardner, Senator Hill, co-sponsors, Senator Jones, you're on the bill. Oh, please add the president. Mr. Majors, would you please read the title to House Bill 1144?
House Bill 1144 by Representatives Becker, J. and Pedersen, Senator Grantham, concerning transparency of post-secondary courses offered to high school students.
Senator Grantham.
Thank you, Mr. President. I move House Bill 1144 on third reading and final passage and ask for an aye vote.
Is there further discussion? Senator Heath.
Mr. President, with the permission of the bill sponsor, I would like to offer a third reading amendment.
Then would you care to request permission to offer a third reading amendment?
Yes, sir. Thank you, Mr. President.
The request is to grant Senator Heath permission to offer a third reading amendment. All those in favor say aye. Aye. Opposed, no. Senator Heath. Mr. Majors, would you please read Amendment 3 to House Bill 1144?
Amendment L003.
Senator Heath.
Thank you, Mr. President. This is a bill that I really like very, very much, and it basically requires a public high school student's education provider to notify the student or his parent or legal guardian if a student enrolls in a post-secondary course that does not meet the statutory requirements for concurrent enrollment, which I think is very important. If a student's going to do that, they should know what the consequences are. This bill does not have a safety clause in it. I usually don't like safety clause, but without the safety clause, this will not take effect until August, long after the school year is over, and the students right now are basically choosing their courses. I would like to have this bill effective so the students that are now at this position have the benefit of this bill and get that opportunity. So I would move Amendment L003, Mr. President.
Is there further discussion? Senator Grantham.
Thank you, Mr. President. I would also ask for an aye vote. This is the second House. This is the last bite at the apple. This was brought up in committee, and we've been discussing it since then. The senator from Lakewood brought this up, and I think under the circumstances, being the last bite at the apple, I think we should take this action. The senator from Boulder did mention the rationale why we want to make sure that this is in place for the students as they're picking their classes here at the end of the semester, and give them the opportunity to benefit from this statute change just as soon as possible. Thank you.
Is there further discussion? Seeing none, are there any no votes? Senator Sonnenberg? With 34 ayes, Senator Baumgartner. With 33 ayes, 2 noes, 0 absent, 0 excused, Amendment 3 is adopted. To the bill. Senator Grantham.
Thank you, Mr. President, and thank you for that, colleagues, and I just simply ask for an aye vote.
Is there further discussion? Seeing none, the motion before the body is the adoption of House Bill 1144. Are there any no votes? With 35 ayes, 0 noes, 0 absent, 0 excused, House Bill 1144 is adopted. Co-sponsors, Senator Heath, Mr. Majority Leader, Senator Lundberg, Senator Ulibarri, Senator John, Senator Baumgartner, Senator Marble, Senator Jones, Senator Carroll, Senator Cook, Senator Lambert, Senator Merrifield, Senator Kerr, Senator Scott, Senator Crowder, Senator Hodge, Senator Donovan, Senator Neville, Senator Sonnenberg, Senator Kafalis, Senator Todd, Senator Roberts, Senator Martinez-Huminick, Minority Leader Guzman, Senator Johnston, Senator Woods, Senator Hill, Senator Stedman, Senator Newell, Senator Holbert, please add the President. General orders, second reading of bills, consent calendar. Senator Crowder.
Thank you, Mr. President. I move the Senate resolve itself into the Committee of the Whole for consideration of general orders, second reading of bills, consent calendar.
You have heard the motion. All those in favor say aye. Opposed, no. The ayes have it. The Senate will resolve itself into the Committee of the Whole for the consideration of general orders. Second reading of bills, consent calendar. Senator Crowder will take the chair.
The committee will come to order. The court rule is relaxed. Mr. Majors, would you please read titles to all the bills on the general orders second reading of bills consent calendar?
House Bill 1085 by Representative Thurlow, Senator Tate, concerning simplifying the process for returning to a prior name after a decree of dissolution or legal separation has been entered. House Bill 1011 by Representative Vigil and Senators Garcia and Grantham, concerning the removal of restrictions on the authority of a border metropolitan district to provide activities to support business development within the district.
Majority Leader Scheffel.
Thank you, Mr. Chairman. At this time, I move that the committee adopt the two bills listed on the general order second reading of bills consent calendar, which includes House Bill 1085 and House Bill 1011. Ask for an aye vote.
Is there any discussion? The motion before the body is the adoption of all bills on the general order second reading of bills consent calendar. All those in favor say aye. Aye. Opposed, no. The ayes have it, and the bills of the consent calendar are adopted. Majority Leader Scheffel.
Thank you, Mr. Chairman. At this time, I move that the committee rise and report.
The motion is for the body to rise and report. All those in favor say aye.
Aye.
Opposed, no. The ayes have it, and the motion is adopted. The committee will rise and report.
The Senate will come back to order. Senator Crowder.
Thank you, Mr. President. The committee has had a number of bills under consideration. Mr. Majors, would you please read the report?
March 10, 2016, Mr. President, the committee holding reports under consideration of the following tax bills, being second reading thereof, makes following recommendations thereon. House Bill 1085 and House Bill 1011 passed on second reading in order to revise and place on the counter for third reading and final passage.
Senator Crowder.
Thank you, Mr. President. I move for the adoption of the report.
The motion before the body is the adoption of the report of the Committee of the Whole. Is there further discussion? Seeing none, are there any no votes? With 35 ayes, 0 noes, 0 absent, 0 excused, the report of the Committee of the Whole is adopted. House Bill 1085, House Bill 1011 passed on second reading in order revised and placed on the calendar for third reading and final passage. General orders, second reading of bills. Senator Crowder.
Thank you, Mr. President. I move the Senate resolve itself into the Committee of the Whole for the consideration of general orders, second reading of bills, second reading of bills.
You have heard the motion. All those in favor say aye. Opposed, no. The ayes have it. The Senate will resolve itself into the Committee of the Whole for the consideration of general orders, second reading of bills, calendar. And Senator Crowder will take the chair.
The committee will come to order and the court rule is relaxed. Mr. Majors, would you please read the title?
House Bill 1151 by Representative Boone and Senator Holberg, concerning the expansion of penalty mitigation under the alcohol beverage laws for vendors and meeting the definition of a responsible vendor as provided by law.
Senator Holberg.
Thank you, Mr. Chairman. I move House Bill 1151. There is no committee report.
To the bill, Mr. Holbert. Senator Holbert.
Thank you, Mr. Chairman. House Bill 1151 would allow the Liquor Enforcement Division to take into consideration training of employees on best practices related to selling liquor to minors, to intoxicated persons. This kind of discretion is allowed when there is a sting operation from law enforcement, and this bill would allow such consideration in instances outside of those sort of sting operations. I believe the good senator from Boulder has an amendment, so I will step out of the way.
That was the committee, right? No, that was the amendment. Senator Heath, discussion on this?
Thank you,
Hold on,
Mr.
hold
Chair.
on. Stand by. That was the amendment.
Yeah, he needs to be, well, no, he hasn't actually, yes, okay, there's an amendment on the desk.
There is an amendment on the desks.
Yes, Mr. Majors, read the title. Okay, recognize Heath.
Senator Heath.
We have the amendment read? Yeah, that's what I would say.
Okay, Mr. Majors, please read the amendment.
Amendment L002 to House Bill 1151 by Senator Heath, amending reading Gross Bill, page 2, line 12, strike.
Mr. Heath. Senator Heath.
Thank you, Mr. Chair. We had a really good discussion on this bill in committee, and I think it is a good bill. This amendment does one thing, and I move amendment L002. This amendment does one thing. It adds the word employees. Our concern was that we're offering extenuating circumstances to an employer who provides training to his employees. And this would be usually in a bar situation, and where an employee makes a mistake or doesn't check the license or and verify the employee's age. If the employee has been trained and it's just really the employee acting on his own, this would give extenuating circumstances to the employer who's provided that training. What I wanted to make sure in the way this bill read without this amendment, it could be interpreted that the employer, even if he does it himself and violates his own rules, could get extenuating circumstances for this. Just wanted to make sure it only extends to the employees, so we're inserting the word employees, and the sponsor and I have talked about this, and I appreciate his support of this amendment.
Senator Hobart.
Thank you, Mr. Chairman. I do consider this a friendly amendment. During committee, we talked about how we could not apply the grace to the actual employer, the licensee, so that it would only apply to employees. And after we adjourned the committee, we realized, wait, we're thinking about this backwards. Instead of not applying it to the employer, let's put the words employees in there so that it only applies to employees. I consider a friendly amendment.
Is there any further discussion? Seeing none, the motion before the body is adoption. Senate bill, or the amendment L002. All those in favor say aye.
Aye.
Those opposed, same sign. The ayes have it, and the bill, to the bill, Senator Hobart.
Thank you, Mr. Chairman. Again, ask for an aye vote on 1151.
Further discussion on the bill. There is a bit. Seeing no further discussion, all those in favor of this, please say aye. Opposed, same sign. Motion carried.
Okay, rise. Mr. Majority Leader.
Mr. Majority.
Thank you, Mr. Chairman. And at the conclusion of the fine work of the Committee on the Whole, I move that the committee rise and report.
All those in favor, rise and report, say aye. Motion carried. Are there any noes? Where is it?
Senate will come back with thank you, Mr. President. The committee has met and had a blah, blah, blah. And I move the adoption report. Majors calls for or reads the report first. But thank you, Mr. President. The committee has met and had one bill under consideration.
The Senate will come back to order. Senator Crowder.
Thank you, Mr. President. The committee has met and had one bill under consideration. Mr. Majors, would you please read the report?
March 10, 2016, Mr. President, the Committee on Whole Business reports under consideration the following attached bill being the second reading thereof makes following recommendation thereon. House Bill 1151 is amended, passed on second reading in order to revise, placed on the counter for third reading and final passage.
Senator Crowder.
Thank you, Mr. President. I move for the adoption of the report.
The motion before the body is the adoption of the report of the Committee of the Whole. Is there further discussion? Seeing none, are there any no votes? 35 ayes, 0 noes, 0 absent, 0 excused. The report of the Committee of the Whole is adopted. House Bill 1151 is amended, passed on second reading, and ordered revised and placed on the calendar for third reading and final passage. Consideration of resolutions. Mr. Majors, would you? Majority Leader Shuffle.
Thank you, Mr. President. I move that the Senate lay over the consideration of resolutions calendar to follow the consideration of governor's appointments consent calendar.
You have heard the motion. All those in favor say aye. Those opposed, no. The ayes have it. The consideration of resolutions calendar will lay over to follow the consideration of governor's appointments consent calendar. Consideration of governor's appointments consent calendar. Mr. Majors, would you please read the appointments?
Members of the State Board of Parole, effective November 23, 2015, for a term expiring July 1, 2016. Alexandra Jennifer Walker of Sedalia, Colorado, serves as a citizen representative indication by the resignation of Brandon Carey Schaefer of Longmont, Colorado, appointed. For term expiring July 1, 2018. John M. Odell of Loveland, Colorado, serves as a law enforcement representative, reappointed. Members of the Colorado Commission on Judicial Discipline, effective July 1, 2015, for term expiring June 30, 2019. Yolanda Lyons Fund of Monument, Colorado, to serve as a non-attorney, reappointed. Elizabeth Krupa of Evergreen, Colorado, to serve as an attorney, appointed.
Majority Leader Shuffle.
Thank you, Mr. President. I move that the Senate confirm the governor's appointments listed on the consideration of governor's appointments consent calendar, which includes members of the State Board of Parole and members of the Colorado Commission on Judicial Discipline.
You have heard the motion. Is there further discussion on any of the appointments? Seeing none, are there any no votes on any of the appointments? With 35 ayes, 0 noes, 0 absent, 0 excused, Alexandra Jennifer Walker and John M. Odell are appointed as members of the State Board of Parole. With 35 ayes, 0 noes, 0 absent, 0 excused, Yolanda Lyons Fund, Elizabeth Krupa are appointed as members of the Colorado Commission on Judicial Discipline. Consideration of resolutions. Mr. Majors, would you please read the title to Senate Joint Resolution 11?
Senate Joint Resolution 11 by Senator Grantham and Representative Wilson concerning discouraging the lease of the CSP2 facility in Canyon City to the federal government.
Senator Grantham.
Thank you, Mr. President. I move Senate Joint Resolution 11, and I won't ask it for it to be read at length.
To the resolution.
Thank you, Mr. President. Folks, I think under the circumstances, if you can read, you can check it out for yourself. What a nice concept.
Is there further discussion?
That is a big if.
Seeing none?
May I continue, Mr. President?
Yeah. Senator Grantham.
President. Folks, I appreciate your the brief levity, at least at this point, on this resolution. At least for folks down in my area, in Canyon City, Fremont County, this is a very serious issue. Canyon City, Fremont County has a very long and good tradition and history of housing the worst of the worst in Colorado. It is not something that we have ever shirked duty at. It is something that prior to even statehood we have embraced. And it's an interesting dynamic down there now with the potential from what we've heard from the president in his speech just a few weeks ago, that there is the potential of bringing the remaining Guantanamo Bay prisoners stateside and closing down that facility. We've held meetings down in Canyon City on this topic. We've gotten a lot of feedback from citizens down there, including members of and staff and guards, correctional officers, et cetera, at facilities down in Canyon City and Florence. And I've yet to hear one positive comment about the prospect of bringing these prisoners into Colorado or Fremont County. I say that nicely. In fact, the comments are quite the opposite of nice. It is the expressions used are not repeatable here probably at this mic, and I'll leave that to your imagination. The fact of the matter is they're not wanted in Fremont County. The point of this resolution, and I know we'll probably try to work to bring it back around on this resolution several times. I know there's some desire to talk about this and for changes to be made in this resolution. But I'd like to keep the eye on the ball here in what we're doing with this resolution. This is simply about a single facility in Canyon City because it is the vacant facility that's been the focus and the attention of the possibility of moving these Guantanamo Bay detainees, the place that would be moving them to potentially, if they came to Colorado. And the focus here is, what does federal law tell us? We have 5 times, including the current fiscal year in the National Defense Authorization Act for 16 and 17, seen the prohibition of the use of federal funds to transfer Guantanamo detainees to any facility on U.S. soil. And that is, I think, where I want to keep the focus here, folks, and that is the purpose of this, that this facility will not be used because of the current federal law. Now, the question then comes, what would be the effect if the federal law changes? Well, then obviously the discussion will be into politics and policy, and that's fair. But for right now, current law, federal law, says no money, no federal funds to transfer these detainees to any facility on U.S. soil. And the resolution and its goal and its purpose is to simply say, let's recognize that and let's follow federal law and not bring them to Colorado and not use that to bring them to what is commonly known as the CSP2 facility in Canyon City. We know by the words of many folks, many organizations here in Colorado, that they are not wanted to be brought here to Colorado. The Colorado sheriffs have openly opposed this. The Attorney General has recognized the illegality of bringing them here because of what I've already mentioned. We even see the recognition from the governor so far on this, and I would simply ask through this resolution that we as a body would recognize that as well. That currently, under current federal law, this is illegal. The president a few weeks ago did talk about finally closing the facility and transferring the remaining 91 detainees or at least a large percentage of them, to a U.S.-based facility. We still don't know what that means. Granted, that we don't know if that means Colorado. We don't know if that means any other facility. We don't know what kind of facility, a federal facility, a state facility. But we would like your support in Canyon City to say not here. And there are many reasons that we could probably point to, and most of the ones that are pointed to by citizens in Canyon City and Fremont County is a fear of safety. And we can talk about those in some detail, and I imagine we probably will here shortly when others come up to talk, and we can certainly debate that if you like. But from their standpoint, and these are not folks that shirk at their duty of keeping prisoners. We've done this for well over 100 years, before statehood, 150 years, give or take. This is not an unfamiliar place for us in Fremont County. But to a man and woman in Fremont County, we say no. This is not an option. These are not the prisoners that we want here in Fremont County, not because of the inability of any of our facilities and the people on the wall to be able to guard these prisoners and to keep them in line and safe behind the wall. But there are safety concerns outside the wall and in the community. And we've seen this in other locations. And concentrating these prisoners here in this one place at this one time would not be a wise plan, regardless of what federal law says or doesn't say. There are many other points, Mr. President, that we could make, and I'm sure that we will have a great opportunity here shortly as other people want to talk. And so, Mr. President, I will relinquish the mic and allow others to have their say, and we'll go from there. Thank you, Mr. President.
Is there further discussion? Senator Stedman? We have amendments. Mr. Majors, would you please read Amendment 5?
Amendment L005, Senate Joint Resolution 11 by Senator Stedman, amendment printed.
Senator Stedman.
Thank you, Mr. President. I move Amendment L005. And colleagues, this is an issue I take a great interest in. I've done a lot of work actually on the facility in question. And Amendment 005 actually corrects the record a little bit to change the references in the resolution to where it currently says CSP2. It would change it to the Centennial South Campus of the Centennial Correctional Facility, which is the official name of the facility, and this is how we refer to it in statute. And so it seems like it would be nice to true up the resolution and what we're talking about with how we refer to this facility in statute. The amendment also references House Bill 12-1337, which is a bill the Joint Budget Committee passed in 2012. Myself and Senator Lambert were co-prime sponsors on this bill. And this is the bill that closed CSP2, or better, as it's commonly known, but the Centennial South Campus, and specified that the Department of Corrections may not use the facility for the purpose of housing inmates in housing units. And it further directed the Department of Corrections to actively pursue options to sell or lease the facility. Now, the last thing, and the Amendment L005 quotes from House Bill 1337 when we closed the facility. And I think it's important to provide this in the resolution just so you have some context here about what it is the resolution is calling for. The Amendment 005 finally also adds to the resolution the fact that in the upcoming fiscal year, 16-17, Colorado taxpayers will spend $20,258,268 on the debt service on a facility that sits empty. That's what we're debating, and that's what this resolution is about, is we have an empty prison that was built for reasons that we could debate if we wanted to get off topic. that we used only for a very, very brief amount of time. We only opened one wing of the building. It only housed inmates for, I think, about 6 or 9 months, and the General Assembly made the decision to close the facility. And it sits empty, and it's still not even paid for, and taxpayers are spending over $20 million a year on the debt service. That's the facility in question that this resolution pertains to, and Amendment L005 adds to the resolution these facts about how the facility came to be empty and how much we're spending on it, also corrects the proper name of the facility. So I'd ask for an aye vote on 005.
Senator Lambert.
Thank you. Thank you, Mr. President. I stand in favor of L005. I'd like to expand a couple things, because when we're talking about putting, and we're not even sure what the status of these prisoners are coming from, if they happen to come from Guantanamo. Are they federal prisoners? Are they international prisoners? They're sort of prisoners without status. But the problem is, with the South Campus of the Centennial Correctional Facility, it is completely encumbered with the rest of the state facilities that are there. How do you define what this campus is if you're using it for other uses other than housing state offenders? We have had an interesting series of documents that have been prepared as part of our discussions about this problem in the Joint Budget Committee. The department position was that we should not use this. It was documented in the department hearing briefs. We should not be using this for international criminals. And that is also the department's position as well as the governor's position. Last year, however, we appropriated, I think it was $25,000 for a follow-on to the prison utilization study. We've just called it Prison Utilization Study 2.0. And that has recently come back to the JBC. It's a document, so anybody would have access to it. But along the lines of our questioning of how we could possibly reuse this facility in discussions with DOC, the study came back I think, with some very favorable recommendations that we can use the South Campus, the vacant $200 million a year facility, for certain types of Colorado offenders. We will be discussing those options next week. I think it's Tuesday in the Budget Committee. And one of the options is to use the facility down there for our initial entry facility for offenders coming into the DOC system. And you can, during that period of time, put some of those offenders temporarily into maximum security units, where it would not be favorable to do that over a long period of time in administrative segregation. The philosophy of how to deal with administrative segregation has changed dramatically over the last, let's say, 8 or 9 years, where the requirements that were explained to the Budget Committee at that time for opening this facility were very specific, that we need more administrative segregation units. I was on the committee at that time, and based upon the department's request for more administrative segregation units, we built CSP2. We provided the money for that. However, with changes of directors and change of prison philosophy about what works and what doesn't work, the department and just public policy has changed, so we do not have the same requirement for administrative segregation units. That's the reason why the facility is vacant right now. It's important to realize also on this particular amendment that we do have another path ahead. If we used that for the entry facility or a re-entry facility for DOC, we could put some of the offenders that are currently down in the Centennial facility who need medical assistance, who need other types of treatment programs. If we can put those in the Denver prison, they'll be a lot closer and more convenient for medical treatment in a downtown urban area that has a lot of specialty care than they are, frankly, in Fremont County. So the study has already been done. It goes along very much the same lines of what we've asked about as possible options. I think it's validated those options. So I think this is an opportunity just to bring the body up to speed about those options, much better options for this facility. We will try to cut out the bleeding of $20 million a year and actually use this facility for a good purpose, and I think probably improve in the long run the entire DOC system. But as part of a larger resolution today that we should not be using this for other purposes, I think we have found a state purpose that would be a good replacement for it now.
Senator Grantham.
Thank you, Mr. President. And folks, I will ask for an aye vote on Amendment 5. The sponsor of the amendment did very graciously share the amendment with me ahead of time, and we're able to talk about a couple things on this, and including a follow-up paragraph that will be soon to come, and I will ask for an aye vote.
Is there further discussion? The motion before the body is the adoption of Amendment 5. Are there any no votes? With 35 ayes, 0 no, 0 absent, 0 excused, Amendment 5 is adopted. Mr. Majors, would you please read Amendment 9?
Amendment L009.
Senator Stedman.
Thank you, Mr. President. I move Amendment L009. And colleagues, this is an amendment to the previous amendment that adds an additional paragraph that goes into exactly what my colleague from the Joint Budget Committee was explaining about the newest rendition of our prison utilization study, and the fact that we have commissioned a study of how we use the state's various prison facilities, and we have received recommendations from the consulting firm that did that about how we might realign the uses of our facilities to actually find a purpose of housing state inmates in this facility that currently sits empty. And so this adds that extra paragraph referencing the prison utilization study and its proposed recommendations. We haven't acted on them yet. They actually have a bit of a price tag to them. I'm not sure what's going to happen in the short term, but I think this is something the General Assembly definitely needs to be focused on, and I think it's an important addition to the resolution, so I'd ask for an aye vote.
Senator Grantham.
Thank you, Mr. President, and I will ask for an aye vote on this. Folks, in the context of the previous amendment and including this one, talking about the annual payments that we're making on this and the cost that this facility is to the taxpayers of Colorado, and in context of the larger point of the resolution, the idea that a sale of the facilities to the federal government is the only option is simply not the case. We do have other options available to us potentially, and those are and should be explored to the greatest extent possible, including those that are mentioned in the previously mentioned Prison Utilization Study 2.0. And I'd ask for an aye vote.
Is there further discussion? The motion before the body is the adoption of Amendment 9. Are there any no votes? With 35 ayes, 0 no, 0 absent, 0 excused, Amendment 9 is adopted. Mr. Majors, would you please read Amendment 6?
Amendment L006.
Senator Stedman.
Thank you, Mr. President. I move Amendment L006. And colleague, this amendment is very simple. It changes 3 words in the resolution because I find the resolution very interesting. The resolution is titled Discouraging the Lease of the Centennial South Facility in Canyon City to the Federal Government. That's how we've amended the title. And yet the content of the resolution is focused very heavily on detainees at Guantanamo Bay Military Facility. And so, you know, the resolution's about one of our state prison facilities. It's titled that, and yet the content is very much focused on Guantanamo detainees. And throughout the resolution refers to the detainees as enemy combatants, which is actually a term of art from federal law. But there are 3 places in the resolution where it switches tone a little bit and refers to these people as terrorists. And the amendment on the floor would bring consistent language to the entire resolution and refer to them throughout as enemy combatants. I think this is an important distinction, one, just as a matter of law and process. None of these folks that are the subject of this resolution have had a trial. None of them have been found guilty, and none of them have been convicted. They are being detained under provisions of federal law that consider them enemy combatants. And I'm trying to sort of take the tone down a little bit, the temperature down on the resolution by removing some of the words that I think are a little more inflammatory, that tend to make this more emotional, whereas I think this is properly a discussion about state resources and how we allocate state resources. And so I would ask that you adopt Amendment L006 and have consistent language in how we refer to these folks throughout the resolution.
Senator Lambert?
Thank you, Mr. President. I would oppose L06, and here's the reason. This is a very, and it's actually for very much the same reasons that the amendment sponsor has cited. We want to make sure the legal definitions of the people that are being incarcerated is legally correct. The problem is that if, right now you'll notice that these offenders are being kept in Guantanamo Bay, Cuba, on a U.S. Marine Corps military facility. They are being held as military offenders. It has been debated a lot in some of the other trials for terrorism about the status of people who are non-state combatants. They do not represent any particular country that's recognized by the United Nations. However, if we use the term enemy combatants, the presumption could be that they are state actors. What's the difference? If they are state actors and called enemy combatants, they could fall under the protections of the Geneva Convention. And I believe it's Geneva Convention 31, if I'm not mistaken. The problem is that if, and I think the U.S. Supreme Court and others have reviewed this, that their status is not under the Geneva Convention because they are not state participants. They are not state sponsored. They're not part of any particular army or organized group. However, if we use the term enemy combatants, they may be. What's the difference? If an enemy combatant is housed in a state facility that is a direct violation of international law under the Geneva Convention, it crosses a threshold, and it actually would put the state of Colorado potentially in the situation of violating the Geneva Convention, and it could theoretically be a war crime. Since that has not happened yet, we have not had any kind of ruling on that. But my concern is that this could extend Geneva Convention protections and actions to these offenders. So I think the word terrorist is one of those, maybe it is an obnoxious word, but it's probably factual. The problem using the term enemy combatants, I think, elevates that status, gives them the potential of being covered by the Geneva Convention, and then the United States could literally be committing a war crime by putting them in a private prison, which is totally opposed to the Geneva Convention. So I don't think we want to set up ourselves for litigation to being war criminals in the future. So I ask for opposition for L006.
Senator Stedman.
Thank you, Mr. President. I just want to point out to the body that the amendment on the floor would bring consistency to how we refer to these folks. And I'm referring to them in the amendment as enemy combatants, which is language that's already in the resolution. And so if us using those words causes problems, we're already doing that. Page 1, line 4. Page 2, lines 8 and 9. Page 2, line 15. Page 3, line 2, enemy combatant, enemy combatant, enemy combatant. It's already there. And so I don't think there's a reason to defeat the amendment on the floor because these words are problematic. These words already exist in the resolution, and this amendment would make it consistent. Now, I think there's some movement afoot, and I think we may find a better word for all of these. And hopefully I just identified some of the places the amendment needs to go to. But in the meantime, I'd ask for your consideration of Amendment L006 and a favorable vote.
Senator Grantham.
Thank you, Mr. President. There is something afoot, so I would ask for a no vote on this amendment.
Senator Stedman.
Thank you, Mr. President. I will withdraw my motion for Amendment L006 and ask for a senatorial 5.
Amendment 6 is withdrawn, and the Senate will stand in a brief recess. The Senate will come back to order. Mr. Majors, would you please read Amendment L010?
Amendment L010 is a Senate Joint Resolution 11 by Senators Grantham, Stedman,
Senator Grantham.
Thank you, Mr. President. I move Amendment L010 and ask for an aye vote.
Is there further discussion? Senator Grantham?
Thank you, Mr. President. This, in reference to the previous discussion, in the terminology referring to the folks that are being detained, inconsistency as far as the terminology throughout the resolution and consistency with my remarks actually in the beginning of this, in my opening statements, we would substitute all places where it says enemy combatants and terrorists with the simple term detainees and ask for an aye vote.
Senator Stedman.
Thank you, Mr. President. As Ralph Waldo Emerson said, consistency is the hobgoblin of small minds, and for that reason, I also ask for an aye vote.
Is there further discussion? Seeing none, the motion before the body is the adoption of Amendment L010. Are there any no votes? With 35 ayes, 0 no, 0 absent, 0 excused, L010 is adopted. Mr. Majors, would you please read Amendment 7?
Amendment L007, Senate Joint Resolution 11 by Senator Stedman, amend printed resolution, page 2, strike lines 8 through 10, and substitute whereas the detainee is currently
Senator Stedman.
Thank you, Mr. President. I move Amendment L007. Colleagues, this adds a paragraph that acknowledges the fact that the detainees, and as luck would have it, this paragraph uses the word detainees, should be immediately charged and tried for any acts of terrorism and transferred to only the safest and most secure prison facility available. This is an acknowledgement, folks, of what's going on at Guantanamo Bay should concern any civil libertarian. We have held these detainees in this facility outside of American soil, outside the reach of the jurisdiction of some of our laws and remedies for years without trying them, without offering them due process, without giving them a fair trial and an opportunity to be confronted by their witnesses and the evidence against them, without an opportunity to determine their innocence or guilt. They are being held year after year after year. This is, I think, an affront to our Constitution, an affront to our civil liberties. It is not the proudest chapter in American history. It's something that we should end immediately. The U.S. Supreme Court has heard appeals from these detainees and has ruled in favor of the fact that, yes, in fact, they do have habeas corpus rights. They do have the right to be brought before a court and to have their incarceration challenged and determined as to whether it is legally just. I think a great injustice is occurring with these folks, and if we're going to get into a debate about how we use our prison facilities that ventures off into how the United States government is violating the Constitution of our country and the civil liberties of these folks that we're illegally detaining, let's acknowledge that fact and ask that they be given a trial. And if they are guilty of acts of terrorism or acts of war, let them be convicted after having due process and be properly sentenced thereafter. But what's going on right now is a travesty, and it's something that this is an opportunity for us to at least say, we believe people have a right to be tried and a right to have due process and to have their innocence or guilt determined according to our laws. And that's not what's happening in Guantanamo, and it's a shame.
Senator Grantham.
Thank you, Mr. President. Colleagues, I'm going to ask for a no vote on this. I appreciate the senator's passion on this. It says that they should be transferred to only the safest and most secure prison facilities available. Guess what? That's where they're at. The detainees currently held in Guantanamo should be immediately charged and tried for any acts of terrorism. Colleagues, I would say that there's been ample opportunity for that under the current administration, and it has not happened. We could conduct, as according to all history gives us, when we have people that are taken prisoner upon the battlefield, to be given trial by tribunal or any other military method that is available to them and has been available to the current administration to be done and has not been done, but it still could be and should be, but just not on U.S. soil. I simply ask for a no vote.
Senator Stedman?
Thank you, Mr. President. I would just point out, colleagues, that actually this problem predates the current administration. It goes back to the prior administration. And both administrations have had review panels that have looked at the cases and looked at the charges against these folks. They have recommended that these people be released. Both the administration of George W. Bush and the administration of Barack Obama have had procedures in place to examine the holding of these folks in Guantanamo. And yet, even though their review panels have made recommendations, they're still caught up in endless litigation over their habeas corpus petitions. I have a former constituent and a very good friend who's actually habeas counsel to several of the detainees who I spoke with on the phone last week, who was in Guantanamo while we spoke. It was an interesting phone connection. But she was telling me about the conditions in which these folks are being held and the long lengths of time, the hunger strikes they are engaging in to protest their indefinite detention without a trial, without due process, without the protections that our Constitution expects of our government's actions. Both the current administration and the prior administration, both a Democrat and a Republican administration, are responsible and have this on their hands. And it's something that we should take a strong stand and say at bare minimum, a fair trial and due process should be afforded to these detainees.
Senator Lambert?
Thank you, Mr. President.
Colleagues, could we bring the volume down just a little bit?
I'd ask for a no vote on L007. I think the amendment sponsor probably makes a good case for habeas corpus. We need to figure out a path forward on going through with prosecutions. And in some cases, acts of terrorism, acts of murder have been prosecuted successfully in the American federal judicial system. However, that's not the case in the process in Guantanamo. There are two ideas that are merged together in the resolution. I don't see any real mention here of habeas corpus in the resolution of individual civil rights. I don't see that in this amendment. But what I do see is a second idea encouraging the current detainees that they be transferred from Guantanamo. I think the U.S. Congress has made it clear that they are not to be transferred from Guantanamo. I think the attempts to unilaterally release detainees from Guantanamo is a violation of federal law. And if we put this amendment into the resolution, our resolution might also be a violation of federal law under the just the supreme law of the land here being the federal, or the actionable law is the federal law here. So I would ask for that reason a no vote on L007.
Senator Ulibarri.
Thank you, Mr. President. I want to respond to the comments that were just made and clarify that L007 encourages us to pursue our better selves and our founding principles. This says, the detainees currently held in Guantanamo should be immediately charged and tried for any acts of terrorism and transferred to only the safest and most secure prison facilities available. I think we should trust in our founding fathers and those who believe that we should have a system of law that is just. Those folks who are guilty of crimes, let them have a trial. Make sure that they are convicted and that they serve out their punishment. But to hold folks without charging them goes against our fundamental ideas of liberty in this country. Our Constitution is what supersedes. Those concepts are ingrained in our Constitution, the ones that are reflected here in L007. And colleagues, I respectfully urge an aye vote on this amendment to honor our Constitution.
Senator Lambert.
Thank you, Mr. President. And just in response to that, part of our Constitution is the Supremacy Clause. Transfer of these offenders, these detainees from Guantanamo, is a violation of federal law. We have a constitutional process. For the state to suggest that we should violate federal law and violate the Supremacy Clause in this particular case is foolhardy. It is not safe to American citizens. It does not acknowledge all the crimes that these detainees have committed. I think this is consistent. We could still, work out the trial portion of this, but to transfer and put a suggestion that we have to transfer offenders, detainees out of Guantanamo Bay in violation of federal law is not within the power of the state.
Senator Grantham.
Thank you, Mr. President. I simply renew my request for a no vote on this, and will address just one simple thing that was mentioned at the mic here in regard to the current and the prior administration. Yes, it was the Guantanamo Bay facility was put into operation under the prior administration. The number of prisoners peaked at nearly 800. And then more than 500 of those were actually transferred out under the prior administration, and only 147 have since been transferred out, and 91 detainees remain. Why is that? We should ask ourselves that question. Maybe we can come back to that. Why are these 91 still there? Why hasn't this administration moved them out as promised, and as all the other nearly 600 or so, 647 thus far, or give or take, have been moved out? Why are these 91 remaining? Why have they not been moved out in the past several years? The Department of Defense gives us that answer. The Secretary of Defense, Ash Carter, and others talk about the danger of these individuals. These are the most dangerous of the entire bunch, and there's a reason why they are still there. If we were talking about safety and security here, if we were talking about the safest and most secure prison facilities, I reiterate, they are already there. It is called Guantanamo Bay. I ask for a no vote.
Senator Kerr.
Thank you, Mr. President. And I rise in support of this amendment. Down here, we talk about our values and our beliefs, our principles. And we have many values, beliefs, and principles that helped form our Constitution that we hold dear today. Freedom and choice and liberty. My own personal principles ask me to vote for this amendment because perhaps the principle I hold most dear is the principle of liberty.
Senator Jones.
Thank you, Mr. President. I agree with the previous speaker about liberty, and that's what this amendment's about. I'm also interested to see that we acknowledge the Supremacy Clause, and I hope we carry that forward when we talk about federal public lands and their ability to manage those.
Is there further discussion? Senator Merrifield.
Thank you, Mr. President. Not being an attorney, and I know there are those who are much greater learned than I in constitutional issues, I'm just confused and curious as to if we were referring to the supremacy of federal law, and federal law would deny any of those detainees being sent to Colorado anyway, why are we debating this resolution? Why is this resolution necessary?
Senator Crowder.
Thank you, Mr. President. You know, I've heard a few words like principle, values. Ralph Carr in 1943, you know, he stopped the Japanese internment at Camp Amachi. That was principles. What we're talking about here is foreign combatants. We're talking about enemies of this country. And, you know, I do believe that, you know, they should get their justice. I do not believe that they should get their habeas corpus under the guise of the United States of America. So I do, you know, Guantanamo is set there for a particular purpose, and that is enemy combatants of the United States of America. And I do believe that this is more of a political issue because, you know, once there is peace, these people will be released. But until that peace comes, you know, it's in the best interest of this country to keep them incarcerated, and if they can go through the courts of a world court, that's where it should be, but not in the state of Colorado and not in this country. Thank you.
Senator Lundberg.
Thank you, Mr. President. Mr. President, I'm voting no on this amendment. I believe it brings up some interesting points, but it doesn't have relevance to this resolution. This amendment is, as I say, an interesting idea, and I suggest that anybody who wants to support the amendment, or yes, the amendment, might consider a resolution on their own to actually deal with this issue. But the resolution before us is concerning bringing the detainees to a facility in Colorado which Congress has said you don't have the authority to the president, but all indications are that the president is still moving forward with this plan. This is a resolution for the Senate and later the House in the state of Colorado to say, no, this is not a good idea. We do not approve. We do not give our consent to the use of this facility for this federal purpose. That's where we need to be. I'm voting no on the amendment because that's not the point of the amendment. So let's move forward, please, Mr. President.
Is there further discussion? We're still on the motion before the body is the adoption of Amendment 7. Are there any no votes? Senator Crowder, Senator Woods, Senator Martinez-Humenick, Senator Tate, Mr. Majority Leader, Senator Lundberg, Senator Roberts, Senator Lambert, Senator Cook, Senator Neville, Senator Baumgardner, Senator Hill, Senator Marble, Senator Grantham, Senator Holbert, Senator Scott, Senator Sonnenberg. Please add the President. With 17 ayes, 18 noes, 0 absent, 0 excused, Amendment 7 is lost. To the resolution. Is there further discussion? Senator Lundberg.
Thank you, Mr. President. To very briefly state one other element, I actually alluded to it in my previous time up here, but I want it to be clearly understood that the federal government, or more specifically Congress, who has that authority to allow the use of the power and the funds of the federal government to purchase property within the states, only has the authority with the consent of the legislature. It's Article 8 of it's Article 1 of Section 8. it states very clearly that Congress has the authority to purchase land, but only with the consent of the legislature of the state in which it is being purchased. So if this were to move forward, I would give reference to page 3, lines 8 through 15, where it clearly acknowledges that Congress has not given the authority to make this purchase, but further, I would submit that if the Senate states within this resolution, by accepting this resolution, that we are not approving of this purchase, that there is no consent from the state legislature either. And it's for all of those reasons that I believe this is a good resolution that should be approved, and you know, we'll keep the federal government within line of what they can and can't do.
There is an amendment. Mr. Majors, would you please read Amendment L001?
Amendment L001 to Senate Joint Resolution 11 by Senator Ulibarri. Amend printed resolution, page 2, after line 10, insert whereas the General Assembly of the State of Colorado condemns the use
Ulibarri?
Sorry, Mr. President, I didn't raise my hand. I was hoping that the amendment would be read at length.
Please continue.
Whereas the General Assembly of the State of Colorado condemns the use of enhanced interrogation techniques such as whalings, abdominal slaps, cold water dowsing, sleep deprivations, beatings, waterboardings, nudity, rectal feeding, rectal rehydration, extreme temperature fluctuations, and stress positions, as well as any withholding of information regarding the use of extreme interrogation techniques by the United States from the United States Congress and relevant federal and state agencies. Quote.
Senator Ulibarri.
Thank you, Mr. President. I move L01.
To the amendment.
Thank you, Mr. President. Colleagues, as it stands, Senate Joint Resolution 11 indicates that the facility in question, the one that's in the title, is available for lease by the state government. In fact, the federal government has come and seen the facility and said, we don't want it. We actually don't want to house anyone there. We've acknowledged that now with our amendments that we've adopted, that the federal government doesn't want that facility. It's a red herring. And so what we have before us in Senate Joint Resolution is a statement, one that's largely focused around the Guantanamo Bay detainees. And because of that fact, here's an additional statement, which is we as the General Assembly should condemn the use of those enhanced interrogation techniques, also decried as torture, deployed by our government, which have been used to recruit terrorists throughout the world. When we talk about these things like wallings, that's the practice of putting a collar around a detainee's neck so they can be snapped against a wall to force out information, or the beating of folks against their abdominal muscles, cold water dousing or waterboarding, sleep deprivation, forced nudity, the insertion of food or water through the rectum. Those are things that we have found out to be true of what happened in Guantanamo Bay. What we also know, and what bipartisan opponents have said, the use of these practices, including U.S. Senator John McCain, that doesn't get us the kind of actionable intelligence that we need to keep our country secure. What it does is make us less safe. By using torture, we provide a reason, a rationale, for those who conspire against us to recruit. And I bring this up today because what we know is that Senate Joint Resolution is just a statement. There is no binding effect. It's already been discussed around our supremacy clause and the fact that the federal government has come and visited the facility and said, in fact, we don't want it. So if we're making a statement, let's make the real statement, that we condemn the use of these types of tactics because they make us less safe. Previously, a speaker said, well, we shouldn't use this certain term because we might be guilty of war crimes. Let us take responsibility for the things we've done and condemn those things that were done in our name, that we don't support. It should be that simple. Today, this is relevant. The leading candidate for the Republican nomination for president keeps saying, I want to make sure we have waterboardings and worse, that we want to go back to these kinds of techniques, and I think we collectively can condemn the use of torture. This resolution has provided the forum for this conversation, and it's one that we collectively can stand up and say, The General Assembly of the State of Colorado opposes these techniques. They do not make us more safe. In fact, they threaten our security. For that, I ask for an aye vote on L01.
Senator Grantham.
Thank you, Mr. President, and I appreciate the amendment sponsor's passion on this issue, and it sounds like a great topic for another resolution. Just doesn't fit under the title of mine, and ask for ruling from the President.
Point of order. Point of order, there's no title ruling on resolutions. They're not legislation. They don't have the same rules.
Senate will stand in a recess. The Senate will come back to order. Senator Grantham.
Thank you, Mr. President, and thank you for that clarification on that, being this is a resolution. Senator, thank you for the amendment. And again, to my point, this has nothing to do with the resolution and what it's calling for us to do. I appreciate your passion on this, and I would simply ask for a no vote. This doesn't belong in this resolution.
Further discussion? Senator Crowder.
Thank you, Mr. President. I'm going to be an adamant no vote on this amendment. You know, this is what we're talking about here is, you know, if there were people out there that were in the military, you would understand that this is not the way we in the military operate. We are not animals. We are not barbarians, and we know that. The thing about it, well, we do not, under the Geneva Convention, these issues are already addressed. So this does not belong with this resolution. And I basically, to bring up an individual who's running for president on this is in my opinion, not relevant whatsoever. Because anybody over the age of 26 could run for president and say that. So, but you know, as American veteran, I'm somewhat offended by this particular issue here. Because what we do when we get into military situations, we fight to win. We do not torture in that respect, and I fail to believe or recognize that we do.
Is there further discussion? Senator Garcia.
Thank you, Mr. President. And I would acknowledge that I think we could point to, as an Iraq war veteran who served in Iraq in 2003, the fact that we saw cases of torture and practices that were unacceptable at Abu Ghraib in Iraq. This has been well documented. I rise in support of this amendment.
Senator Jones.
Thank you, Mr. President. I also ask for your support of this amendment. Earlier, the comment was made that if we call these people enemy combatants, that means that the Geneva Convention would come into place. And I agree, these people, many of them probably did very, very horrible things. But I want to remind you what our country is based on, and that is we're better than many nations because of our values. And people in World War II prisoner of war camps would be very supportive of this. I had an uncle, last name of Color. He was 6'2", and he came out of the prisoner of war camp in Germany at about 110 pounds. He would be very supportive of this, I'm sure. Then you think of John McCain, what happened to him at the Hanoi Hilton. And that's why he thinks this is horrible. I want to please, people, think about our country and what we're voting on here and what a no vote says here.
Senator Guzman.
Thank you, Mr. President. I also rise in support of this amendment. The words in this amendment only reiterate what we here in America believe in, and what actually all of the countries that are part of the goodwill of this world acknowledge. This amendment only acknowledges and respects the Geneva Convention. It just reiterates who we are as Americans. And I think this is important to include in this statement, not in this proposal. Thank you very much.
Is there further discussion? Seeing none, the motion before the body is the adoption of Amendment L001. Are there any no votes? Mr. Majority Leader? Senator Grantham? Senator Scott? Senator Marble? Senator Tate? Senator Lambert? Senator Crowder? Senator Cook? Senator Neville? Senator Roberts? Senator Baumgardner? Senator Martinez-Humenick? Senator Woods? Senator Sonnenberg? Senator Holbert? Senator Lundberg? Senator Hill? Please add the President. With 17 ayes, 18 noes, 0 absent, 0 excused, Amendment L001 is lost. We are back to the resolution. Is there further discussion? Senator Kerr.
Thank you, Mr. President.
We have an amendment. Mr. Majors, would you please read Amendment L008?
Amendment L008 to Senate Joint Resolution 11 by Senator Kerr.
Senator Kerr.
Thank you, Mr. President. So with these resolutions, one of the things that is often stated down here in the debate is that these resolutions really are...
Senator Kerr, you must move your amendment.
Thank you, Mr. President. I move L008. One of the things that gets talked about and debated down here at the well is the purpose of these resolutions. And one of the things that we often hear is that these resolutions are really just a letter to Santa Claus. That we come down here and we debate them, but they have no legal standing. They have no weight of actual law behind them. And that we send these resolutions, if they pass in a joint resolution like this, pass both chambers, and then we send them on to Santa Claus or whoever else we're going to send them to read and take notice of them. So this resolution, at the very end, page 3, it says, "Be it further resolved," after it talk about all the other language, all the other amendments, some good amendments that I think we've done today. It asks that that copies of this joint resolution be sent to the President of the United States, Speaker of the House, Senate Majority Leader, Secretary of Defense, goes on. So these are people that obviously would want to know how we feel and what our whereases are on this resolution. So that's why I think we need to make sure that anyone in any group that is interested in this resolution, interested in the language of this resolution, interested in the direction that we as a body are taking and sending those letters, that all of these groups get a copy of this resolution. Because at the end of the day, why do our kids write that letter to Santa Claus? They want something. They want Santa Claus to know what it is that they want in their heart. So I think it's it only makes sense that we make sure that these letters get to Santa Claus or anyone else that wants to know what is the will of this body. Thank you.
Mr. Majority Leader. Thank you, Mr. President. What we do here every day is very important. We all got here the same way. We all worked really hard to get here, and I appreciate the intent, the spirit of the senator from Fremont County for bringing this. I also appreciate the collaborative work that has gone on. I was chatting with the minority leader earlier, and it's always a pleasure to see when we can come together and work on things, and that's what we've seen today. We have to be careful what we say from this podium because, by all accounts, it is never appropriate to question motives or to inappropriately criticize the work that goes from this podium. It's important. The paper that leaves this place in the form of resolutions, bills, tributes, leaves this place with the seal of the state of Colorado on it. And that's important because it means deliberation, discussion, things have gone on here. And in honor of that, I ask for a no vote on Amendment 8.
Is there further discussion? Madam President Pro Tem, please relieve me.
President Cadman.
I'm going to share 3 words, and you can figure out the meanings for yourselves. 16 years. 16 years. Three words: despicable, reprehensible, offensive. Is there further discussion? Seeing none, the motion before the body is the adoption of Senate Joint Resolution 11. Amendment? What? My apologies for that. Senator Kerr.
Thank you, Mr. President. I withdraw L008.
L008 is withdrawn. The motion before the body is the adoption of Senate Joint Resolution 11. A roll call has been requested. Mr. Majors, would you please poll the senators?
Senators Aguilar. Aguilar, no. Baumgartner. Baumgartner, aye. Carroll. Carroll, aye. Cook. Cook, aye. Crowder. Crowder, aye. Donovan. Donovan, I. Garcia. Garcia, I. Grantham. Grantham, I. Guzman. Guzman, I. Heath. Hill. Hill, I. Hodge. Hodge, I. Holbert. Holbert, I. John. John, I. Johnston. Johnston, I. Jones. Jones, no. Cafalis. Cafalis, I. Kerr. Kerr, I. Lambert. Lambert, I. Lundberg. Lundberg, I. Marble. Marble, I. Martinez Humenic. Martinez Humenic, I. Merrifield. Neville. Neville, I. Newell. Newell, no. Roberts. Roberts, I. Scheffel. Scheffel, I. Scott. Scott, I. Sonnenberg. Sonnenberg, I. Stedman. Stedman, no. Tate. Tate, I. Todd. Todd, I. Ulibarri. Ulibarri, no. Woods. Woods, I. Heath. Heath, no. Merrifield. Merrifield, no. Mr. President.
Aye.
Mr. President, aye.
With 28 ayes, 7 noes, 0 absent, 0 excused, Senate Joint Resolution 11 is adopted. Co-sponsors: Senator Baumgardner, Mr. Majority Leader, Senator Holbert, Senator Crowder, Senator Scott, Senator Marble, Senator Neville, Senator Lambert, Senator Cook, Mr. Majors, would you please read the title to Senate Joint Resolution 14?
Senate Joint Resolution 14 by Senator Neville and Representatives Everett and Leonard concerning the designation of United States Highway 285 from mile marker 238 to mile marker 245 as the Sergeant Sean P. Renfro Memorial Highway.
Majority Leader Scheffel.
Thank you, Mr. President. I move the Senate lay over Senate Joint Resolution 14 to March 14th.
You have heard the motion. All those in favor say aye. Aye. Those opposed, no. The ayes have it. Senate Joint Resolution 14 will lay over until March 14. Message from the House.
March 10, 2016, Mr. President, the House has passed on third reading Transfer the Advisor Statute, House Bill 1279 as amended.
Message from the Reviser.
March 10, 2016, we hear with the transmit without comment as amended, House Bill 1279.
Message from the Governor.
March 9, 2016, Colorado Senate. Ladies and gentlemen, I have the honor to inform you that I have approved and filed with the Secretary of State the following acts. Senate Bill 4 concerning the enactment of the Colorado Revised Statutes 2015 is positive statutory law of the state of Colorado approved March 9, 2016 at 4:00 p.m. Senate Bill 9 concerning the sharing of professional dental fees approved March 9, 2016 at 3:36 p.m. Senate Bill 15 concerning a requirement that a governor designated state agency clarify which pesticides may be used in the marijuana industry approved March 9, 2016 at 3:49 p.m. Senate Bill 20 concerning clarification of certain calculations of the automatic funding mechanism for payment of future costs attributable to certain of the state's capital assets approved March 9, 2016 at 3:53 p.m. Sincerely, John W. Hickenlooper, Governor.
Announcements. Senator Lundberg.
Thank you, Mr. President. Members, the committees will be meeting as listed in the calendar with the exception of with the Senate Ag Committee. Senate Bill 61 will be the last bill heard. That will be moving behind House Bill 1170, so it will be Senate Bill 61 as the final bill to be heard in Senate Ag today.
Committee reports.
March 9, 2016, Committee on Business, Labor, Technology, after consideration, the Mayor's Committee recommends the following House Bill 1090 be amended as follows and as amended before the Committee of the Whole favorable recommendation. March 9, 2016, Committee on Health and Human Services, after consideration, the Mayor's Committee recommends the following House Bill 1236 be referred to the Committee of the Whole favorable recommendation. March 9, 2016, Committee on Health and Human Services, after consideration, the Mayor's Committee recommends the following House Bill 1168 be referred to the Committee of the Whole favorable recommendation.
Further announcements. Senator Baumgartner.
Thank you, Mr. President. Members, just a reminder that Colorado Technology Association is having an event down at Mile High. It's called Sea Level at Mile High. Begins about 5:30 this evening. If you'd like to attend, please come and see what's new in the technical world.
No, this is past that. Further announcements. Senator Tate.
Thank you, Mr. President. Today at noon in House Committee Room 111, Metro State University is having a lunch event. So please join Metro State.
Where is the lunch?
Again, it's House Committee Room 111.
Further announcements. Senator Todd.
Thank you, Mr. President. Good morning, colleagues. On Monday, there is an opportunity for us to meet and learn more about Refugees 101 in the old Supreme Court chamber from 11:45 to 1:30. There will be lunch provided. And again, Refugees 101, this was on your desk earlier this week, I think. So come and join us. Thank you.
Is there further announcements? Mr. Majority Leader.
Thank you, Mr. President. Colleagues, if you're so inclined or find yourself in need, there's a doctor of the day in the Capitol. One Dr. Katie Seitz is here and ready to give aid where needed. With that, Mr. President, I move the Senate adjourn to 9 a.m. Friday, March 11th.
You've heard the motion. All those in favor say aye. Opposed, no. The ayes have it. The Senate will stand adjourned until 9 a.m. Friday, March 11th.